Hello all and greetings. I first of all thanks the organizers for providing me an opportunity to speak on this topic or present my article on this topic, understanding liquidated damages in construction contracts through an analysis of court judgments. Now the question comes like, what is this topic doing in the context of COVID-19 scenario that we are discussing? See, the context of the article, what I would like to put it across is that uh, COVID-19 can potentially trigger a number of delay-related issues in future. Right now, it has resulted in problems like force majeure related issues, but it can also trigger delay-related damages and such issues in future. Now, parties have to contractually prepare for such claims in the future. So when it comes to preparing for such claims, one of the best way to prepare is to understand what the previous judgments of the court or the precedents that has been set, so that we can be confident about the contractual process that we are following to ensure that whether we are putting the claim or defending the claim, we are contractually secure. Okay. So, in this article, some typical questions related to understanding the nature of liquidated damages and related claims are discussed with the help of certain precedents established by the previous court judgments. Now, again, I would like to reiterate that so many actions have to be taken in the course of the contract so that uh, your position with respect to liquidated damages is secure in the future. Now, uh, the impact of COVID-19 is not going to stop with only force majeure clauses. It's definitely going to show up in terms of many delay-related issues, probably towards the end of the project, and that's where liquidated damages comes into picture. And for that, the groundwork has to be done in the progress of the contract. We cannot do anything once the issue of this damages comes up. So it's a continuous process, and the groundwork has to be done during the course of the contract. And some of the typical questions that arise in the context of liquidated damages is discussed here. So the first question which I would like to put forth in my article is that if an extension of time is provided by the employer without levying liquidated damages, then can it be considered as an implicit admission by the employer that delays are attributable to it, to that is to the employer itself. So from the court decisions, it appears that if an employer has not levied LD, it is not an automatic admission of delays. However, it may be considered as an admission of delay if the employer is unable to properly justify uh, that the delay is attributable to the other party. So essentially, it means that just by keeping quiet or just by not levying LD, it doesn't mean that the delays automatically shift to the other party. It has to be proven. And the next question that arises out of this is a notice required to be given to convey the intention to levy liquidated damages? And yes, this is required, and even section 55 of Indian Contract Act also puts this across, that if you, especially when the time is essence of the contract, it has the intention has to be conveyed. This is particularly true in case of time being the essence of the contract. So this understanding I have derived by understanding certain judgments of the courts and the references of all such court judgments which I've considered to arrive at this understanding is something that I have presented on the screen that you can see there. Uh, the second question which I would like to pose is, in case of recovery of liquidated damages from sums due to the contractor, should the party give proof indicating the extent of damage? So this has been elaborately discussed in the judgments of the high courts and the Supreme Courts across the country. One thing is very clear, that wherever it is possible to quantify losses, it needs to be quantified. This statement I say because if you look at the construction of Section 74 of Indian Contract Act, there are two parts in that. The first part says that whether or not delay has occurred, the party claiming damages has to be compensated if there is a sum mentioned in the contract. On the next part of the same clause says that the claim that is being made must be reasonable in nature. So the question might come as to how come the submission of proof, or if you say that proof submission is not required, then how do you establish reasonableness? This question might come. So that is very clearly established by the courts, that wherever it is possible to quantify damages, it has to be quantified. Okay, so proof is required in all places where it is possible to prove. Of course, in the celebrated judgment of ONGC versus SAW pipes, of course, it was later again discussed in the Sasong construction and NHAI case. But in the ONGC versus SAW pipes case, it was, the court made it very clear that uh, if it is, in certain cases it may not be possible to prove it, certain typical road projects or some government projects which is done for the sake of public, it might be difficult for the public client to prove the extent of losses, and such cases maybe a different view can be taken. But wherever it is possible to prove the losses, or the quantify the losses as a result of the delays caused by one party, uh, so there has to be some sort of a proof indicating the extent of damage. So that is not what is waived off just because you are mentioning liquidated damage clause in your contract, right? Um, when there is an LD clause in the contract, can unliquidated damages be claimed separately? So this, on reading this particular case which is there on the screen, that is NHAI versus Bridge and Roof Company Construction Company Limited, it appears that having incorporated LD clause in the contract, the employer may not be able to claim unliquidated damages separately, which was explained given the circumstances of that particular case. Of course, case to case, it has to be seen, and whether this can be literally translated into another case is something that depends upon the facts of the case. Then the burden of proving reasonableness or unreasonableness, because this is something that is indicated already in section 74, that the claim that is being made under liquidated damages has to be reasonable in nature. So who should prove the reasonableness, or who should challenge the reasonableness or unreasonableness? So it is very clear, the burden of proof lies with the claimant. If a sum is agreed in the contract, the party who claims it as not being reasonable or who claims it to be reasonable must prove accordingly when challenged. Okay, so that is being discussed in some of the cases that have been referred to in the presentation as shown in the screen. Then comes the power of the court to reject or award LD claims. This I'm specifically talking about it because um, there are certain contracts where a provision is included like this. That is, provision of the included like this, that LD percentages that are mentioned in the contract are agreed as genuine pre-estimate of losses and not by the way of penalty. Now the question comes that if such a provision is included in the contract clause under liquidated damages, then does it make the percentages that has been agreed by the parties as a reasonable percentage automatically just because it has been agreed as genuine pre-estimate of losses? Again, this has been discussed in a number of cases, especially the ONGC versus SAW pipes, and also the National Highways Authority on Sesong construction versus Sesong construction. And something which I could derive out of understanding these cases is that uh, in any case, whether it is written as genuine pre-estimate of losses or not written as genuine pre-estimate of losses, if it is possible for the parties to prove damages that has occurred, then it has to be proven. That is, it has to be, if it is quantifiable, it has to be quantified. That has been discussed previously also. But if it is seen that quantifying such losses or proving such losses is difficult, then in the event genuine pre-estimate of losses, this provision is mentioned, then the party claiming LD, uh, it might be possible that they can go for a full recovery of whatever LD percentage that has been mentioned. But in case it is not mentioned, it is not given in the contract that it is a genuine pre-estimate of losses and not by the way of penalty, then the court is competent to award what is reasonable on the basis of established principles. In any case, subject to the maximum limits prescribed in the LD clause of the contract. Of course, that is there in any case. You cannot exceed more than what is written in the LD clause of the contract. So that is always there. So again, this is something that has been discussed elaborately in various cases, and again needs to be taken into consideration from looking at the facts of the case. So this is something that I could find from the I could understand from the reading of the judgments. But again, when you are extending it to a particular case in hand, we need to take into consideration the facts of the case as well. So we cannot literally translate this into the case in hand. Then, can security deposits submitted as bank guarantees be revoked towards recovery of LD amount? So it may be possible. Courts have observed that the forfeiture will be subject to the limits. Again, when it is possible, the forfeiture will be subject to certain limits that is agreed in the LD clause of the contract, because LD clauses are subjected to an upper cap, and recovery cannot be made beyond this upper cap. But one thing that needs to be with contractors needs to be careful here is that when an employer invokes a bank guarantee, there is no need for any reason to be given to the bank to invoke that. So it's a tricky issue here, and this has to be also looked in conjunction with uh, the court judgments on invocation of bank guarantees. So I would like to leave it here. I would not take it up further here, because it has to be looked along with that. And as I told you, this is an ongoing work, and I'm looking at it further. Okay. The next point which I would like to put across here is that the issue of breach and liability automatically excluded from arbitration when quantification of liquidated damages are excluded from arbitration. That is, if the quantification of liquidated damages are coming as a part of accepted matters, then does it mean that the breach and liability requirement, proving the breach and liability, is also included as an accepted matter? The answer is no. The courts have consistently held that the issue of fixing the responsibility of delays and quantifying losses as a consequence of the same are two different aspects. So therefore, uh, you cannot escape from the requirement of proving which party has caused the loss, and also proving the delays that has resulted, proving the delays that has happened. So that is required, but the extent of losses, it may be excluded from the purview of arbitration, but that doesn't mean that the responsibility of proving the responsibility or fixing the responsibility of delays is also excluded from arbitration purview. That doesn't mean it doesn't mean that way. Okay, so the courts have consistently held that the issue of fixing the responsibility of delays and quantifying losses as a consequence of those delays are two separate issues, right? So inclusion of quantification of losses as a consequence of delays as an accepted matter does not automatically mean that fixing of responsibility is also included in as an accepted matter. So that is what is something that's coming out from some of the judgments relating to this particular question. So finally, these are the 7 topics that I had considered in my article. And as I told you, it's an ongoing article, and it would be great if I can receive some sort of guidance and feedback in terms of additional supports or some cases which can help in improvising this particular article. And overall, I'm trying to come out with these kind of questions for every issue that a construction environment we face. It might be prolongation claims, it might be acceleration claims, and this is an ongoing work which I'm doing. And slowly I would like to come up with some of my observation in other kind of claims as well, and other typical issues as well. And my contact details are here. Please do get back to me in case you have any comments, feedbacks, or suggestions or guidance with respect to this topic and whatever I've discussed. I'm still learning in this process, and I seek your help and support. Thank you very much for the opportunity. Hope to interact with you sometime later. Thank you very much.